Thank you all for joining us today on what I hope will be an interesting and interactive session on adventures in medical malpractice. I'm Jess Hackle, retired general pediatrician, practiced for 41 years. In addition to my roles at the AAP, which you see listed, I've been serving as a reviewer and as an expert witness in medical malpractice cases for over 35 years. So over that time, I've certainly seen an awful lot of issues, of cases raised, some pretty good and some pretty awful. So I hope to go over some of them and make them instructive cases with the ultimate goal of keeping everybody who's doing the kind of work we do out of as much trouble as we possibly can. We have Slido because this is an interactive presentation. When I discuss some cases, we're going to ask for people to vote on some of the outcomes and some of the conditions involved, and we'll discuss your responses to that as well as the eventual outcomes of the cases. So if you've got the chance to sign in for Slido, pick the talk on You Be the Jury, and when the polls pop up, you'll be able to give your opinions, and then we can go forward and discuss them. I wanted to start with a couple of basic principles about malpractice before we get to the cases. Now, it's a given that anybody can sue anybody for any reason at any time. So when you start from that, the question is, what is it that differentiates the outcome of a lawsuit filed alleging medical malpractice? And there are 4 criteria that need to be met for a plaintiff to prevail in a medical malpractice case. The first criterion is that the physician must have a duty to provide appropriate care. And we'll talk about what appropriate care means in a moment. But that the physician must have a duty to provide care to the patient. And we sort of assume that that's the case once you accept a patient into your office, into your practice. You've established a physician-patient relationship, which implies that duty to provide care. The second criterion is that the physician must have breached that duty. And that's where the question of negligence comes in. If you are negligent in performing that duty, if you don't provide it up to the standard of care, which again goes to appropriate care, then the physician may have breached the duty. The third criteria, though, also applies even if the physician has breached that duty. Has the patient suffered an injury or a loss as a result of that breach? In other words, there are many times when the duty is not fulfilled and yet there is no harm caused to the patient. And that, again, will not enable a patient to prevail in a malpractice suit. It's kind of a no harm, no foul decision. And then finally, that breach of duty must have been the direct cause of the injury or loss. If you've breached the duty and if the patient suffered a harm, but that harm was caused by an auto accident on the way home, again, there's no relationship of the breach of duty to the loss. So again, the patient could not be expected to prevail in that circumstance. When we talk to pediatricians, I've got good news and bad news. The good news is that pediatricians, out of 25 specialty surveys, pediatricians are the 24th least likely to be sued. So that is some good news, and yet, 3% of all pediatricians do get sued every given year. We like to think it's because we do good work, but really it's because we maintain our patient relationships and our family relationships well. And we interact with our patients because it has been shown that having a good relationship with a family is much of a protective benefit in terms of the likelihood of a lawsuit, even in an adverse outcome. And of those 3% who get sued, only about 1/5 actually, when they go to trial, result in a payout on behalf of the pediatrician. So even if you get sued, you've got a 4 out of 5 chance of being found not negligent and not having a payout, which then would get reported to the data bank and all that sort of stuff. So the odds are really good for being a pediatrician. The bad news, however, is that when a claim payout is made, in pediatrics, it tends to be one of the highest of any specialty. You know, OBs, neurosurgery, pathology, and neurology have higher payouts, but then come pediatrics. So if you do have an adverse outcome, if the jury does find for negligence, the likelihood is that the payout will be large. The other negative is that cases in pediatrics take a long time to resolve. For a lawsuit to be filed on a timely basis, you have to meet the filing deadlines, which normally the statute of limitations in most states runs for 3 years after the incident. In pediatrics, it's 3 years plus the age of majority. Now, the age of majority in most states is 18, so if you're talking about care of a newborn, you've got 18 plus 3, or 21 years, where you can be on the hook for your care. Now, that's an awful long time. No other specialty, when you're dealing with adults at least, has that same risk. So, again, there's good news and bad news when it comes to pediatrics. I mentioned the standard of care. And that is a definition that is not a medical definition. That's not talking about the standard treatment for a condition. The standard of care refers to the procedures and the actions that a competent physician in the same field would take under similar circumstances. And this has been defined by the courts. At some point, it was felt to be reflecting a minimally competent physician, but that's kind of, that word minimally has been removed, and so it really reflects an average competent pediatrician. What that person would do in a similar circumstance, the same kind of clinical presentation, sometimes includes a geographic location, although that is less commonly seen today. So it does not require you to be perfect. You don't have to be acting as the absolute best pediatrician in the world. You have to be taking the steps and taking the care that an average pediatrician would do in those circumstances. And it also does not reflect outcome. Nobody determines the standard of care based on whether your care or your treatment is successful. So it's important to keep those things in mind. We're not expected to be godlike, and we're not expected to never make a mistake. But we need to be careful and provide care according to the standard of care in order to prevail. So with that, let me go over a couple of cases. Now, these are real-life cases that I have dealt with, that I have reviewed at some point during my career. Some of them have been modified to protect the innocent. Others have been modified to make the case and the clinical presentation a little bit more clear. But these again reflect cases that are commonly seen in pediatrics, situations that are commonly seen in pediatrics that sometimes lead to adverse outcomes and often are the cause of lawsuits being filed against pediatricians. So the first case is a 7-year-old boy who came home from his sports camp and who was complaining of pain in his lower abdomen, but without nausea, vomiting, or fever. His pediatrician saw him urgently that evening and documented the exam as being normal, including no focal abdominal tenderness, a soft abdomen with normal bowel sounds, normal genital exam, and a positive cremasteric sign. He was diagnosed with a muscle strain and sent home with analgesics and told to return if the pain continued or worsened. These records were received directly from the pediatrician. I received them from the pediatrician's lawyer, and review of the chart showed documentation of all of the above. So the first poll is to ask you, up to this point, had the standard of care been met in caring for this child? In other words, had this physician done the examination the way an average competent pediatrician would have done under the similar circumstances? And your choices are yes, the exam was thorough and well documented, no, the exam was incomplete, or no, adequate instructions for follow-up care were not given to the patient. So we'll take a moment, go ahead and vote on the poll. Okay, and the results are still coming in. The majority of people feel that the exam was thorough and well documented, but a number of you feel that the exam was somewhat incomplete. So we'll move on a little bit further and follow the case. The following day, the pain had worsened, and the child presented to the emergency department. Ultrasound showed a lack of blood flow to the left testicle, and surgical exploration was performed, revealing a necrotic left testicle. A left orchiectomy and a right orchiopexy were performed. The parents subsequently filed suit alleging negligence in diagnosing a testicular torsion with a missed opportunity to salvage a viable testis. Now, as a lawsuit is filed, it goes through a phase known as discovery, and this is where further investigation is done into the facts behind the case. This involves additional documentation, it involves deposition testimony of the parties involved, and it's important to note that during discovery, the attorneys for both sides are required to exchange any information that they discover with the opposing side. This keeps things out in the open and prevents surprises at the time of trial. So during discovery, these attorneys exchanged documents, and I subsequently received a packet of documents to look at, in addition to the records I had seen earlier. Reviewing the pediatrician's chart, which was sent by the plaintiff's attorney, showed a normal exam, again with documentation of no focal tenderness, a soft abdomen with normal bowel sounds, normal genital exam, and a blank area. He was diagnosed with a muscle strain and told to return if the pain continued or worsened. Now, if we flip back to the original records that I reviewed, you can see the difference, okay? And so the question then is, what comes out and what is the outcome of this lawsuit? So this is the second poll. What was the outcome of this case when the parents filed the lawsuit? Choices being that the case was successfully defended at the trial based on documentation with a defense verdict. The case went to trial and resulted in a verdict for the plaintiff, or the third choice being that the case settled prior to trial. Okay, and overwhelmingly, people have the answer that the case settled prior to trial. And the reason for this settling is that there was a clear discrepancy between the records that were received from the defendant physician and those received from the plaintiff's attorney, specifically concerning the notation of a positive cremasteric reflex. Now, after some further inquiry, it was revealed that the parent had requested a copy of the records shortly after the incident occurred. The defendant did not provide the records until after a lawsuit had been commenced. So the timeline involved was that the incident occurred, the parent received records, the lawsuit was filed, and then the defendant physician provided records. And what that conclusion that was reached that I suspected and that the defense attorney agreed with is that during the interval between the incident and the lawsuit, or once the lawsuit was filed actually, the records were altered to add the note about the cremasteric reflex. Altering a record, aside from being a no-no, and it's something that should never be done, but it makes, one of the reasons is that it, aside from being wrong, is that it makes a case very difficult to defend. It's almost an admission of guilt if you change your records after a lawsuit has been filed. Even if the physician were not negligent, a jury will doubt the veracity of anything the physician says once the alteration is discovered. Now, one of the other take-home messages here is clear that if records are ever sent from your office, the date, the requesting party, and the receiving party need to be documented and need to be available. I like to think that if a physician knew that the records had been sent previously, it would make the idea of altering the records aside from being wrong, even a worse idea. And this case was potentially defensible, depending on the physician's testimony, until evidence of alteration of the records had occurred. So you take a case that could be defended, and you turn it into something where you're guaranteed to lose, to the point that there's no point in even taking it to trial. And that's what happened in this case. So again, we all know that altering records is a bad idea. But no matter how great the temptation to do it is, there are lots of ways that you're going to get tripped up. It's worse now. I mean, these records were on paper. This goes back a number of years. But now with EHRs, every keystroke that you enter in a chart is documented in terms of the time and date. And by getting the audit trail for that record, it's clear whenever a record was entered and whenever something was changed. So never alter your records. It's wrong. It's unethical, and it can land you in a lot of hot water by turning things that could be prevented and defended into things that no longer can. And again, document when you send your records anyway, because you need to know who's got access to your patient's charts. Okay. We'll move on to the next case. There's a female newborn who's delivered from a vertex presentation following an uneventful pregnancy. Normal nursery exams on 2 separate days documented that the hips were normal and there were negative Barlow, Ortolani, and Galeazzi signs found. She's seen at the pediatrician for visits according to the Bright Futures, and I'll show you those details for the documentation in the next slide. Walking was slightly delayed to 15 months, and by 20 months, the parents were concerned that the child had an abnormal waddling gait. The pediatrician on exam found nothing abnormal, but the concerns persisted, so she was seen by a pediatric orthopedist at 24 months of age. The pediatric orthopedic exam documented normal hip exam and normal hip mobility, but x-rays revealed bilaterally dislocated hips with formation of pseudoacetabulae. She underwent several surgical procedures, and at follow-up, the femoral head still remained underdeveloped, leading to concern about later development of Perthes disease. The parents initiated a suit against the pediatrician for failure to diagnose hip dysplasia early enough to allow non-operative treatment with a greater possibility of long-term success. Now, what's interesting in terms of the documentation is I've actually reviewed 2 cases that were virtually identical to each other with slightly different documentation, but even identical to the fact that the pediatric orthopedist at around 2 years of age found normal hip exams. And so I wanted to compare the 2 of them and talk about some differences between the 2 cases in terms of documentation and care and evaluation of the child for this condition. So the first child had the normal newborn exam, and at the 2, 4, 6, 9, and 12 months, documentation of negative Ortolani and Barlow examinations. The child was not walking at 12 months, was taking a few steps by 15 months, and by 18 months was walking well and climbing steps. And at 20 months, when the parents expressed their concern, the gait was described as normal, normal hip range of motion, and equal leg lengths. The second child had the same newborn exam. At 2, 4, and 6 months, the documentation was for normal hips with no clicks or thunks. At 9 months and 12 months, the musculoskeletal exam was documented as normal. At 15 months, was walking by history. At 18 months, had a wide gait. Was able to stoop and recover, and at the 20-month visit when the parents expressed concern, the hips were noted as being not tight and the gait was normal. So very similar clinical presentations, somewhat different documentation in the records. And so for the first poll on this case, up to this point, had the standard of care been met? And it's yes for child A, no for B, no for child A, yes for child B, and yes for both children or no for both children. And again, the differentiation has to do with the wording in the documentation. Okay, and I would agree with your opinions here that despite the differences in the wording, the case can be made that the standard of care have been met in terms of the clinical examinations for both children. The wording does pose some problems, which is what I will discuss next, because we've decided that the standard of care was met. The examinations were done on an appropriate, timely basis following the Bright Futures guidelines. The intervals were normal. The documentation did not necessarily use standardized language, did not specifically discuss the testing that was performed, but were basically within the range of the kind of documentation that is needed to show that the hips were in fact normal. And finally, the follow-up was appropriate because up until 20 months, there was no concern expressed. There were no abnormal findings noted, and therefore normal normal examinations according to the Bright Future schedule is appropriate to continue to assess these children. So the problem is that when you start to deal with language that doesn't express the details of the examination, the exam may have been appropriate, but how can you be sure? And we get into the concept here of using boilerplate language, which never changes. The wording was the same in the first child at every visit through 12 months. The wording was the same in the second child for the first 6 months of life. There's also the fact that words matter, and so using non-standardized terminology, not describing your examination by an accepted terminology, can lead to problems in interpretation. Both doctors testified at their depositions about the examinations that they performed. The one who discussed it by name, the Ortolani and the Barlow, was able to describe the exams appropriately. The second physician, who noted no clicks and thunks, was also able to describe having performed those examinations in a standard manner, even though the documentation didn't reflect the name of the test. So both of them were able to provide evidence that they had in fact done the appropriate examinations. And yet, we're faced with boilerplate language, which is often on the basis of drop-down menus. You may have a drop-down menu which has fixed choices, and you may not have adequate choices listed in your choices of the drop-down to express exactly what you've done, what you've found, and therefore that can create some problems. So let's go and discuss the outcome of the lawsuits. Both parents filed lawsuits in these cases. Was there liability of the physician in child A, in child B, in both cases, or in neither case? And agreed, absolutely, there was liability in neither case. Both cases were tried. They ended up with verdicts for the defense. So these did go to trial. These did take an extended amount of time to go through the entire process, which of course is a stressful time period for the physician who has to defend themselves. So it's not that there is no cost when you get a defense verdict. You've still gone through an awful lot. But they both ended successfully in verdicts for the defense. Now, the reasoning was that in child A, the Ortolani, the Barlow, and the Galeazzi exams through the 6-month visit met the standard of care. The fact that they were performed at the 9-month and the 12-month visit is outside the standard of care, because as we know, those tests really lose their validity once the child reaches 6 months. So the fact that the exam was continued to be documented suggested that boilerplate and drop-down menus were used in the documentation. This didn't pose a problem because the critical 6 months were appropriate, but nonetheless it leads to the situation where you may have things in the chart that are no longer appropriate based on the age. And the child B, the physician was convincing that the wording referred to the proper examinations, which did vary with the age according to the standard of care. And finally, based on the evidence, we know that developmental dysplasia of the hip is well documented to be absent at birth. It is no longer what we used to way back when call congenital hip dysplasia. If you refer to the condition as congenital, you're assuming that it's present at birth. And the preferred term now is used as developmental dysplasia. The pediatricians use that term, the pediatric orthopedists use that term, and there are many cases and much in the literature which note that you can have normal hips for the first 6 months or a year of life and still show up with dysplastic hips in the second year of life. And if even the pediatric orthopedist at age 24 months will document normal hips, it's hard to expect a general pediatrician to pick up on something that the specialist cannot pick up on. So the outcomes were good, the documentation was good, but it's important to be as precise as you possibly can. So make sure your exams are appropriate for the patient age. Make sure you document the specifics of the exam at every age, and that includes using standard terminology. Be careful with your drop-down menus and your templates. If you didn't write the template, if you didn't write the drop-down menu, make sure you know what's in it. Make sure you know all of your choices. Make sure they give you the choices that you need for your particular examination. Edit them, edit them, edit them. Make sure your EHR allows you, like PCC, to make changes in these drop-down menus. When I practiced, we used one which did not allow that, and we had some bizarre choices in some of the drop-down menus for various conditions. We could not change them, so it became necessary to free text if necessary, and it was necessary a lot. And you know, free texting is a problem because it's time consuming, and it requires you to be accurate. So it sort of defeats a lot of the purposes of having an EHR. And after this morning's discussion of ambient scribes, I just wanted to mention, if you're using an ambient scribe or AI for your office notes, make sure after the fact that the note reflects your examination and your thought process, because AI shortcuts from what is heard to what is written. If you're doing a hip exam and you don't say out loud, this is a negative Ortolani and a negative Barlow examination, an ambient scribe is not necessarily going to put that wording into your note. So you do need to be careful with the documentation, even if you're using the scribes. And you know, it involves sort of talking your thought process out loud, which may be disconcerting in some cases, both to the physician and to the parents, to hear a lot of this going on. But if you're using these tools, it's important that they document exactly what you're thinking, should you ever be faced with having to defend yourself in a malpractice case. Okay, next case is an 18-month-old child who was seen at a pediatric urgent care center with a history of having grabbed a piece of sharp metal and sustaining a laceration of his left index finger. His immunizations were current, and the physician in the urgent care center noted a transverse laceration which was just proximal to the PIP joint on the index finger. There was significant bleeding initially, but it had stopped by the time of the visit. The physician cleaned and bandaged the finger and sent the child home to be followed by the primary care physician in 2 to 3 days. He was actually seen 5 days later by the pediatrician, who noted that there was early healing with erythema and that there was no discharge. The mom noted that he was keeping his finger extended in the bandage, which the pediatrician explained as being due to swelling and discomfort. He rebandaged the finger, and the child was told to follow up if there was drainage, if there was persistent pain, or if there were any other problems. So, up until this point, had the standard of care been met? Options are yes by both the urgent care and the primary care physicians, yes by the urgent care physician, no by the primary care physician, no by the urgent care and yes by the primary care, or no by either physician. Okay, and this is great. We've got, a lot of difference of opinions on this one. And this is great because I think this case is quite instructive. And so given that we have a fairly uniform division of opinions here, my review of this case, I felt that neither physician had met the standard of care in taking care of this patient. When he was seen several months later for a routine visit, he was noted to still be unable to flex the finger, the index finger at the PIP joint. At that point, he was referred to a hand surgeon who made the clinical diagnosis of a transection of the flexor digitoris profundus tendon. They performed a surgical exploration which confirmed the diagnosis. The proximal segment of the tendon could be located, but the distal segment was not, and primary repair could not be done. Therefore, nothing could be done to fix this. He now has persistent inability to flex the finger at the PIP of what has turned out to be his dominant hand. And his concert pianist career has been permanently damaged. The parents filed suit against both the UCC and the physician and the primary care physician. So what was the outcome of this case? Both defendants were found negligent by a jury. Neither defendant was found negligent by a jury. Only the UCC physician was found negligent. Only the PCP was found negligent, or something else. Okay, well, most of you agree that both physicians were negligent. However, this case never went to jury. Never went to trial by jury. Following review by an expert in pediatrics, myself, and by a hand surgeon, it was determined that the standard of care at the initial visit required, at a minimum, referral at that initial visit to a hand surgeon, given the location of the laceration. It may or may not have been possible to repair the tendon at that time, depending on the actual injury, but the chance for restoration of normal function had been lost by failure to do an exploration promptly. Failure to refer at the 5-day visit also missed any chance of repair, even though it was less likely, because of the number of days that had passed. And the defense attorney was unable to locate any experts, either in pediatrics or in hand surgery, who could counter this opinion. So the case was settled before trial on behalf of both physicians with a significant payout to this child, who now has a permanent disability on his dominant hand. And the take-home message for this case is that sometimes the deviation from standard of care is just so obvious that it's easier on both the plaintiff and the defendants to have a case resolved as quickly as possible. When you resolve a case, you want to make sure that defendants who are truly injured by negligence receive the compensation that they're entitled to. And resolving a case by settling before trial enables that to happen much more quickly. It also helps in a case where there's significant deviation from the standard of care. It helps to avoid the emotion that's present in a jury trial. We've all heard stories of bringing a child who suffered significant damage before a jury and getting sympathy from the jury, even in cases where the medicine and the evidence is somewhat questionable. The sympathy at the time of trial often works in the plaintiff's favor. So you remove by settling it, you remove the possibility for an even worse decision and a greater payout. And finally, getting rid of a case where, I hope nobody is ever in a position where they've been negligent, but if that happens, getting rid of a case early before you have to go through months and years of worry and sleepless nights and the torture of having your every move questioned is sometimes easier on the physician as well, to have it settled early, to have it settled before dragging everybody through the emotions. So sometimes when the deviation is that severe, it's advantageous to everybody to end it and make it go away as quickly as possible. So another case, the full-term infant born by cesarean section after a failed labor had rupture of membranes for 12 hours. Maternal group B strep status was unknown, but otherwise the history was benign and no perinatal antibiotics were given and no blood work was done in the newborn nursery. Child did well in the newborn nursery other than a mild elevation of bilirubin and was discharged on day 4 following the section with a 24-hour follow-up and a weight of 3,305 grams. 4 days after discharge, which is day of life 8, the weight was up, the transcutaneous bilirubin was down, the exam was normal, and the child was afebrile, but was seen again the following day with a rash. The weight continued to increase, suggesting adequate feeding, and the diagnosis of the rash was erythema toxicum. The following day, day 10 of life, a call was received from the emergency department that the infant was seen with a temperature of 102, a heart rate of 220, and was admitted to rule out sepsis, had a sepsis workup done in that ED. The child rapidly deteriorated, was transferred to a tertiary care center, and the sepsis workup from the initial ED visit grew E. coli meningitis. So the child had a very stormy course, developed brain abscess and infarction, and survives with severe sequelae. So, in this case, was the standard of care met in the newborn nursery, including the discharge planning? Choices being yes, the care was appropriate, as were the follow-up plans. The care was appropriate, but follow-up should have been ensured, or the care was below standard. Okay, well, I agree that the care was appropriate. I think the follow-up plans, since this baby was discharged at day 4 of life, were probably appropriate. If this had been an early discharge following the ruptured membranes, it might be a little bit questioned, but I do believe that the care and the follow-up were appropriate here. So the parents filed a lawsuit alleging misdiagnosis of E. coli meningitis. They sued both the pediatrician in the hospital as well as the primary care pediatrician. So what was the outcome of this lawsuit? A trial verdict for the plaintiff, a trial verdict for the defendants, a pretrial settlement, or something else? Okay, this case provided a little bit of an interesting wrinkle that I actually had not seen before. I felt that this case was defensible on behalf of all of the defendants based on the fact that while the child developed meningitis, it had nothing to do with group B strep, it was E. coli, and we know that E. coli neonatal infections are unpredictable related to the birth history. So my pediatric review felt the standard was met, but there were other factors that came into play. I mean, the first, as I mentioned earlier, we had an infant who was severely damaged, and bringing this infant into a jury trial was likely to cause an emotional reaction on the part of jurors, which is entirely natural, that could prejudice the case against the defendant. This was in a venue where defendants typically prevail. Where plaintiffs typically prevail. There are certain areas, I'm from New York, and having a trial in Queens or the Bronx is much less favorable than having a trial in Manhattan, because jurors tend to have different approaches to whose stories they believe or to who their sympathies will lie with. So you need to know the area where the trial is being handled in order to know what the jury is likely to, how the jury is likely to take the issue of a child who's been damaged. There was also a problem with one of the defense experts, an infectious disease doctor who had some other issues, not involving medical malpractice cases, but nonetheless had a legal history that could have come out at court and made him at least look like a less reputable witness. And finally, there was concern from the side of the defendants that given the severe injury that this child had suffered, any judgment might exceed their insurance coverage. So this case went to trial, but it went to trial under a circumstance which, again, I had not seen before, where there's a pretrial agreement between the plaintiffs and defense setting both an upper and a lower level limits of compensation. In other words, it goes to trial, but even if the finding is for the defense, the plaintiff is guaranteed a certain amount of payout. Even if there is a verdict for the plaintiff, the defense is guaranteed that there is an upper limit which could be structured within their limits of insurance coverage. So it went to trial. The trial was found in favor of the defendant. And so there was no negligence assessed, and yet the plaintiff was guaranteed a payout which could be used to help to provide for some of this child's care. It enables the jury to decide negligence, and it enables the jury to work on the basis of the evidence and sort of evaluate the care. But it can benefit both parties when you set the limits. And it's an interesting way of looking at things. It helps to relieve the defendant's concern about a case judgment bankrupting them, and it helps to assure that the plaintiff can receive some compensation. These sort of arrangements are less usual, but they will come into play in cases where you're dealing with extremes on both sides in terms of the damage to the child as well as the potential payouts. So it's something to consider, to understand as yet another opportunity, another possible opportunity for outcomes. And so I've got one more case. This is a 4-year-old girl who had a history of several episodes of urinary tract infection where she was seen both in the emergency department and for office visits, who presented to the pediatric emergency department complaining of abdominal pain and painful urination. She was afebrile, documented as having normal bowel sounds and suprapubic tenderness. A urinalysis showed increased white cells, and a urinary tract infection was diagnosed, and she was treated with ceftonir, and a culture was sent. She had a follow-up with her primary care pediatrician a little over a day later. She was still febrile, she was eating without vomiting, she still had suprapubic tenderness, but again a soft, non-tender abdomen with normal bowel sounds, no guarding, no rebound, and no CVA tenderness. The culture results had not yet been obtained, and the ceftonir was continued, and she was instructed specifically to return to either the office or the ED in the event of vomiting, anorexia, fever, or worsening abdominal pain. After an additional 24 hours, she was not improving, but she still hadn't developed vomiting or anorexia, and she went back to the ED. First, she was seen by the pediatrician in the ED and then by the pediatric surgeons, and she was admitted with a presumptive diagnosis of pyelonephritis. She had ultrasound imaging done, which did not suggest pyelonephritis, but did suggest a retrocecal appendicitis, which was confirmed on CT. She was treated non-operatively with intravenous antibiotics and improved greatly, and was scheduled for an interval laparoscopic appendectomy 8 weeks later, which was performed without complication and has continued to do well. The family filed suit alleging delayed diagnosis of appendicitis. They filed suit against both the ED and the primary care for missing that diagnosis. So, for the first poll, was the standard of care met in the ED and by the PCP? Remember, there was an ED visit followed by a PCB visit followed by an ED visit. Was the standard of care met by both? Yes by the ED and no by the PCP? Yes by the PCP and no by the ED, or not by either? And unlike previously, we have really good agreement on this one, and I support that both parties had met the standard of care in terms of both the examination, the consideration of the differential diagnosis, because obviously the note reflected that appendicitis was something that they were concerned with, and by the follow-up planning. So the parents filed suit. And what was the outcome of the lawsuit? Your options are both the ED and the PCB were found negligent. The ED was found negligent, the PCP was not. The PCP was found negligent and the ED was not. And finally, that neither was found negligent. Okay, and this is another case where I agreed that neither party was negligent, but this case also never went to trial. Both defendants separately filed motions for what's known as summary judgment. The ED, which had the visit in between the two, the ED, which had the first visit, filed for summary judgment on the grounds that the PCP had a subsequent opportunity the next day to evaluate the child and discover the appendicitis. The primary care physician filed for summary judgment on several grounds, including the known difficulty of diagnosing a retrocecal appendicitis, the fact that the subsequent ED visit, neither the pediatrician nor the surgeon, who was the usual consultant, felt that there was appendicitis, and finally the fact that the child would have needed surgery in any case. Finally, the summary judgment motion included the fact that the child, other than having had to go through 2 hospitalizations, had no complications or loss from the delay because the subsequent appendectomy was performed without complication and the child has done well. The court granted summary judgment to both defendants. They noted that the failure to make a diagnosis does not constitute negligence as long as appropriate care and evaluation and referral was taken. And that's the key here. The fact that the physicians both considered the diagnosis of appendicitis and felt and documented that appendicitis was not present, even though it turned out to be wrong. They were not negligent in their evaluation of the child. And therefore, they did not meet the criteria, the second criteria that we talked about breach in duty of being negligent in the care. Further, the fact that the usual consultant, the pediatric surgeon, also did not feel that appendicitis was present, just like the orthopedist in the hip dysplasia case, further supported the PCP's claim that the condition was not readily diagnosable, even with a careful and a specific examination. So the take-home points of this case are 2. Thorough examination and documentation, including a differential diagnosis with appropriate follow-up plan, makes a case with an adverse outcome easier to defend. And that's really important because we're going to have adverse outcomes. Not every case goes according to the way we would like it to do. But if you're careful and if you consider the options and make a reasoned decision of why those options do not exist, it's very hard to fault you when one of those adverse outcomes does occur. And I just wanted to mention the concept of a summary judgment. Now, this is a judgment that's rendered by a judge, not with a jury trial, in favor of one party, where there is no dispute about the material facts. In other words, there was no dispute here about what happened to the child and what the exams documented, and that the party moving for summary judgment is entitled to it as a matter of law, which means that given the facts of the case, the party is entitled to ask for a summary judgment. Now, the opposing side may contest the motion, they usually do, and then the judge receives input from both sides, including the motion for judgment, the response by the other side, and then a response to that response, and then the judge will decide based on the evidence. I've seen many cases go this route. It's often something that I recommend when the facts appear clear to me in terms of the nature of the care and the documentation. It's something that if you're ever faced with a lawsuit and you find that there is good support for everything you have done, a summary judgment motion can also short-circuit the course of the entire case and make things a whole lot less onerous for you and a lot shorter in duration into the amount of time you have to deal with it. So finally, in terms of dealing with adverse outcomes, the first thing obviously is to know your medicine. This goes without saying. If you're unfamiliar with the situation, seek help. I mean, when I think of that child with the transected tendon in the finger, when you have a deep cut in an area where tendons go on the fingers, it's important to look to a specialist such as a hand surgeon. Your documentation is always critical, and that case did not even include a differential that included a tendon injury. Had there been discussion of a possible tendon injury and either documentation that the child was moving the finger or that hand surgery was consulted for an evaluation, the outcome likely would have been different. So include your differential diagnosis, and very importantly, include your reasoning as to why you are ruling in or ruling out the items in your differential. Again, it goes back to if you're using scribes, whether it be virtual scribes or actual people in the room, make sure that your reasoning, listen, it goes through our head really fast. We're really good at ruling out a whole lot of items without too much thought, but we need to make sure that we document it in the record because that's what's going to govern the outcome. Follow-up planning is also critical. Anytime you see a child where you have any doubt about what the course is going to be, it's important to give the parents instructions what to do if something happens. Document your instructions and make sure you also document that the parent understands your instructions. Have them repeat it back to you, for example. Remember that the standard of care is not that you have to be perfect. You can be wrong, but you cannot be negligent. And, you know, being wrong is part of human condition, but if you do everything right and the outcome turns out wrong, you can usually be successfully defended in any malpractice actions. So I got a couple of minutes for any questions. Thank you for your attention. I'm happy to answer some questions. Yes? I'm sorry, I'm having trouble.
I said thank you so much.
Thank you.
And I've learned a lot. I just wanted to, in case with E. coli and GBS, what if it was actually GBS that was, would they be liable? Would you, I mean, what would be the story?
That's a good question.
Repeat the question for the folks.
Sure. The question about the child with the E. coli meningitis is, what if it had been GBS, Group B strep, diagnosed with a meningitis? Would there have been liability? And that's interesting. Now, I have reviewed some cases of this, and with Group B strep infection, there are two different clinical scenarios. There's early onset and late onset disease. Early onset disease, which occurs typically within the first 48 hours or so in the nursery, is the type that is related to immediate perinatal birth colonization of the child. And that one, if this child had developed an early onset group B strep infection, there might have been liability for not pursuing the maternal colonization, for not testing or treating the child. Late onset group B strep disease, which occurs typically 5 to 10 days after birth, is a different animal. It's usually meningitis more than sepsis, and there is not an association with whether or not a workup or treatment is done in the newborn nursery. Even those babies who get prophylactic antibiotics for the first 24 hours can still come down with late onset group B strep meningitis. So it really would have depended. In this case where the baby got sick on day 10, it's likely that this case still would have been defensible. But again, the decision of going to trial with boundaries might still have prevailed given the other reasons that I discussed.
Will it be the PCP or the person in the newborn nursery that will be liable, in that situation?
Good question again, and the PCP actions saw the child twice with normal examinations. And no reason for concern, and erythema toxicum obviously being a common rash, PCP would likely have less problem than the physician in the newborn nursery who did not do anything to follow up with the lack of information on the mom's group B strep status.
I'm a little bit intrigued by the way the insurance handled the case with the upper row limits.
Yes.
Was it represented? Did the insurance know that this is her plaintiff entered an agreement that affect payment? Because the payment was when you get a malpractice, if you have liability. If there is no liability, there should be no payment. Everybody, of course, is concerned about the lack of proper care of people that don't have sufficient funds. But that's not the mistake of the malpractice insurance.
That's correct. And yet it is the insurer who proposed this kind of an arrangement.
So the insurance agreed.
The insurance agreed to this. They felt that by guaranteeing a lower payment, even in the case of no negligence, they were able to limit their losses and limit the physician's losses on the other end, on the upper end of the case.
They don't feel secure enough to gamble on the decision.
That's exactly right. This would have been a gamble. And when you're dealing with a child who's damaged at birth and has a 60 or 70 or 80 year lifespan requiring care, you're talking about potentially huge payouts. While we read the stories of $40 million and $60 million judgments, those are devastating to a physician. So the insurance company felt that they could limit their liability. Everybody agreed that it would still be tried in terms of negligence, but that the payout on both ends could be limited within mutually agreed upon amounts.
That makes sense. Because a number of years ago, there was this case, and I think in Mount Vernon, where a newborn was born with some problems and died before the physician that he was assigned get a chance to even see. The jury gave them something like $10 million because that was the limit of the pediatrician's policy. I don't think it's fair for this consideration to be mentioned. I'm sorry. If I haven't seen a patient that got delivered with inappropriate procedures, has been negligent of the mother is negligent, can be negligent as well, and there's some responsibility to passing putting your hand in the jar of of the malpractice is tempting, but in the end, somebody pays for that.
Well, you know, there are other factors that can be involved in a situation where something happens before the child's even seen. Was the physician on call, and did they respond in an appropriate time? Were they notified by the hospital in an appropriate amount of time? So it may not be negligence in the, you know, so there's a lot of factors that we don't understand in that case. Great. Any other questions? Well, thank you all. And my wish for you is that you all avoid adverse outcomes, but that you be prepared should they occur, and work with the people, the attorneys and the insurance companies who have your best interests at heart. So thank you again for your attendance.